Charles Chevelle.
Mr Speaker, I just want to associate the Labor members with what the Minister has said in her first reading speech. It is the case at the moment that the way in which a criminal charge proceeds in New Zealand depends on how the information is laid. There are two choices. As we heard from the Minister, there's the summary jurisdiction where the case is heard by a judge alone, or the indictable jurisdiction where a jury trial is required. As the Minister said, that distinction, which has been one that's long been maintained in New Zealand law, is due to end when the Criminal Procedure Modernisation Bill comes before the House. In principle, the idea of ending the distinction is one that I understand has the support of a number of parties. Certainly the Labor Party supports the idea of ending what is essentially now an archaic distinction. In respect of the mistake that Parliament will correct by passing this legislation, as we heard the Minister explain, there was an attempt to amend the Summary Proceedings Act, an attempt that came into force in June 2008 to exclude three offences from Schedule 1 of the Summary Proceedings Act. The intention of Parliament was that that would result in those offences being able to be proceeded against summarily only. In fact, it's quite apparent from a case decided by a district court in Hamilton in June that the opposite effect was achieved to that which Parliament intended. As we've been reminded, that doesn't mean in respect of the 46,000 potentially ultra vires proceedings since 2008 that some unfair substantive result has occurred. It's simply an issue of having adopted the wrong procedure by which those offences have been tried. Now, I think it's just important to point out that there are two parts to the bill. First of all, Parliament intends to remedy the problem, stop any more ultra vires proceedings occurring. And obviously that's an appropriate thing to do given the error that's been identified here. Secondly, all proceedings that have already occurred will be validated. And there's an important aspect to that. If there has been a challenge to the way in which a prosecution has been brought, then this bill will also preserve the right of a person to continue to bring that challenge. So no rule of law principles are offended. This is a classic example of how Parliament ought to rectify a mistake. It will have the support of members on this side of the House, and I commend the amending legislation.
Chester Borrows.